Hear ye, hear ye, hear ye. Kansas Court of Appeals. The Honorable Sarah Warner presiding.
Thank you. Please be seated. Good morning, everyone. Welcome to the August 2026 oral arguments before the Kansas Court of Appeals. My name is Sarah Warner. I have the honor of serving as Chief Judge on our court. And I'm joined today on a panel with two excellent judges. To my right, your left, is Judge Lori Bolton Fleming. Judge Bolton Fleming joined the Kansas Court of Appeals last year after serving more than a decade in the 11th Judicial District in Pittsburgh. And then to my left, your right, is Judge Teresa Watson from Shawnee County. We're very happy to have Judge Watson sitting with us, and she serves on the 3rd Judicial District. We have 3 cases this morning. Each one is scheduled for 15 minutes of argument per side. In preparation for today's arguments, we have thoroughly reviewed the parties' briefs. We've reviewed the record along with a legal memorandum that's been prepared by a research attorney who works for the court. So all of that is to say, we are very familiar with the facts of the case. And so you have 15 minutes, use that time wisely, jump right into your arguments. And with that, I'll call the first case on this morning's docket from Johnson County, case number 128145. Oh, I'm sorry. Case number from Sedgwick County, case number 129056, in the matter of the care and treatment of Martin E. Palmer. Would the parties please come forward? And would the parties state their appearances?
Johnny, counsel for the appellant Martin Palmer.
Thank you.
Is the court going personal for the state of Kansas?
Thank you. And would the appellant like to reserve any time for rebuttal?
6 minutes, Your Honor.
6 minutes are granted. All right, with that, you may come forward and begin.
Madam Chairwoman, may it please the court. I'm Jacob Ladani, counsel for Martin Palmer. This appeal covers 2 sort of separate issues. There's an evidentiary issue and a issue of the legality of this commitment.
Counsel, I would like to start with the issue of preservation. The state raised some serious preservation issues in its brief. Did you file a reply brief?
I did not, Your Honor.
Okay. I have a lot of questions about whether any of your issues have been properly preserved.
Okay, well, sorry.
Let's start with the arguments about the admission of expert testimony. Tell me a little bit about how you think you preserve those arguments.
So first and foremost, trial counsel on this case, both through pretrial motions and through contemporaneous objections, objected vociferously and continuously to the expert testimony on both issues, both on embrasure of the ultimate issue and on the hearsay or conduit hearsay issue.
But did trial counsel ever raise these constitutional arguments that you've raised in the briefs?
I think trial counsel made the argument without saying the words. So the issues, both of which, so the conduit hearsay, the issue of experts just testifying through the elements, those are issues of fundamental fairness. Procedural due process is the amendment or is the clause that protects fundamental fairness. So Mr. Siebert, in pretrial motions, he said, and I'll do my best to get the quote right, he said, he asked for a Daubert hearing first and foremost. So that's asking for process right there. He was asking for a pretrial process. He then was saying his major concern was that the expert witnesses in these Kansas sexually violent predator cases, they get on the stand, and based on the statutory allowance for experts to rely on evidence that would otherwise be inadmissible or otherwise be hearsay, they get on the stand and they say, in his words, you don't know what they're going to say. And so right there was a request for process in the beginning. There was a request for a hearing with an available relief, that being some sort of limitation on the Daubert factors. So I'd say right there, that's the beginning of preservation.
A request for a hearing is not the same thing as making an argument about procedural due process, is it? I mean, the whole notion of a constitutional violation there never came up in the trial court, did it?
It did not in the issue of the expert witness testimony. There was in the issue of whether this commitment is barred, it did under other terms.
Okay, well, we'll talk about that when we get to that issue, because I would be interested in hearing how you think that happened as well. But when we're talking about the experts, I mean, weren't the basic objections that counsel made in the district court simply hearsay and objecting to the legal conclusions?
Hearsay, objecting to the legal conclusions, they were phrased different ways. Mr. Sievert asked for a standing objection, but based on the current status of the law, the court, there was some colloquy between him and the court that he couldn't actually have a standing objection. And so throughout the trial, he gave different labels to the same objection. So he'd get up over and over and say, foundation, same objection, objection, hearsay. And so he was actively renewing that same objection, which comes down to a whole line or body of objections around that specific topic.
But did any of these objections, were they ever made on the basis of a constitutional violation?
They were made on the basis of hearsay. And so as opposing counsel pointed out, there is no confrontation clause for civil cases. However, as I've argued, there are similar protections or analogous protections to the confrontation clause. So normally the hearsay objection is an objection under the confrontation clause. If it's in a criminal context, you jump up, you say hearsay, that is preserving a confrontation issue.
So, counsel, it seems like we have case law that says that merely making a hearsay objection is not the same thing as making a confrontation clause objection, because there are different elements that have to be proved. Like, for example, if you make a hearsay objection, that's a question with regard to the admissibility of the evidence. The confrontation clause question, is that testimonial? That would never come up in just a basic hearsay objection.
I suppose, Your Honor, but we have the luxury of looking at this in hindsight and not being on the ground. I think that Mr. Sievert made every effort to preserve the issue in this as he was going, and that was in the context he was in. So he had made those arguments. I also think if he made the hearsay objection, there's a question if it's an issue of law and how that affects review, but I didn't brief that, so I'm not going to talk about that.
And I can appreciate you trying to do the best with the record that is available to you. But, you know, part of what we are concerned about as well is the integrity of the process itself. And so if an issue was never presented to the district court, that means that that body never had the opportunity to contemplate that issue, to make findings or make a ruling on that issue that then allows us to review it in a meaningful manner, which is the crux of why 6404 is such a big deal.
I understand, Your Honor. And as you acknowledged yourself, I am working with the record I was given.
Yeah.
So looking through this case, all of this, I think it is an issue of fundamental fairness. That's what it comes down to. And if we really want to go into the factors where you can review something that hasn't been preserved, it goes again to justice, injustice, fundamental fairness. And this is about fundamental fairness. And that's what I've tried to bring into this whole issue, is the way the KSVPA is structured. And some of these aren't the topic of appeal, so I'm not really going to talk about them, but there's a lot about the KSVPA that just is uncomfortable and weird and rests in these very strange areas of law and seems to draw weird loopholes. So on the one hand, It's beyond a reasonable doubt, and there's a right to a jury. But what good is that right to a jury if you can put an expert on there who's just going to read all sorts of stuff to the jury that they went through on their record? And I don't think, I've done a few of these. This one just stood out to me as particularly blatant. When you have experts, especially one who's a lawyer, who's just standing out there saying, well, he meets all the elements, he meets all the criteria. And I understand normally experts can embrace an ultimate issue, but this is so above and beyond embracing an ultimate issue. And that was something that Mr. Sievert also objected about, the embrasure of the ultimate issue, invading the province of the jury. And I mean, when you've got two people standing up there saying, yeah, the first element's met, the second element's met, the third element's met, the fourth element's met. And then you have, again, what is reasonably relied on and how does that make an exception for something? So you have an expert witness who starts going through prison files of other people to find statements about that person. At some point, where is there an end? There is a inherent conflict within the statute because it wants to veneer these constitutional protections onto something where it is trying to take a liberty interest away after a liberty interest has already been taken away. So
I'm curious, and I know you're running out of time on your opening, but I think that we have some other questions for you. But I'm curious, did you find any case law that draws the analogy that you are drawing, that draws the connection between the confrontation clause and due process?
What I found was Galt, which basically it was words by another name. It was the same thing by another name. So they said there's confrontation and Galt. You have a civil commitment, you have a liberty interest, you have a hearsay issue. And so that was the connection I drew. I was trying to look for a standard where one court had applied the most analogous type of proceeding with the most analogous type of results to somebody and what the scrutiny for that type of proceeding was going to be.
Are there any other questions from the panel?
Well, we'll wait for his 6 minutes.
Okay, all right. Thank you.
Thank you.
Thank you. Good morning.
Morning. May it please the court, Dwight Carswell for the state of Kansas. The issues Palmer raises on appeal were not properly before this court because they weren't raised before the district court. Although Palmer did challenge the expert testimony, he never framed that as a due process claim, which is the claim he raises on appeal. And he, in his brief, did not argue why he should be allowed to raise that for the first time on appeal, which the Kansas Supreme Court says you have to do if you're trying to raise something for the first time on appeal. So that completely forecloses his due process claim. As to collateral estoppel, similar issue there. He did not raise a collateral estoppel claim below.
He did raise res judicata.
That's a different issue. I mean, he's raising two different issues. And he is on that one, though, at least in his brief, trying to raise it for the first time on appeal. But that's still discretionary for this court, whether you want to address it or not. Because the district court.
Let's presume that we do.
Okay. So on the merits, all these claims also fail. On that collateral estoppel, it just doesn't apply here. There are two different arguments he makes. One is the Sporn-Sigler material change of circumstances issue. What happens there, that's actually res judicata, not collateral estoppel, which is what he's arguing now. But in that issue, that occurs when there's been a prior commitment and then that failed, and then there's a second attempt to commit someone. And the Kansas Supreme Court said, well, there has to be a material change in circumstances to make those two different cases. Here, there was never a prior commitment, so that's just not, those cases just aren't on point. Issue preclusion occurs or claim collateral estoppel when there's been a prior finding in a case, and then that same issue is being relitigated in a second proceeding involving the same parties. Here, there's no issue that's being determined. He's relying on the 2012 prosecution and claiming that it's the issue of whether that was sexually motivated or not. That was never determined there, as he said in his own brief. The judge never made that finding. And that's also not an issue in this case. The state's relying on the 1990 prosecution as the basis for the commitment, not the 2012 prosecution. So collateral estoppel just doesn't apply. Going back to the merits of the confrontation clause issue, as he admits, the confrontation clause does not apply in civil proceedings. So you have to frame it as a matter of due process, but due process is flexible. Depends on the circumstances. It's not, the confrontation clause principles just don't automatically apply in civil cases. You have to look at what's fair in this circumstances. When it comes to these particular circumstances, where experts are testifying about questions that are really within the scope of expert testimony. I mean, the questions about whether a person has a mental abnormality or personality disorder, whether they're likely to reoffend, whether they have substantial difficulty controlling their dangerous behavior. For an expert just to get up and testify, yes, I think the person does have a mental abnormality, but can't explain. They need to be able to explain the basis for that to the jury for their opinion to be reliable and for the jury to really assess whether they're a credible witness or not. So the experts do need to get into the facts and data that they relied on in order to really have a fair proceeding.
Counsel, it looked like in the In re Norris case, the court formed a requirement that for the underlying data to be admissible, the expert must testify that they relied on that data in forming their opinion. What happened in this case? Did that testimony occur?
I can't point you exactly to the record. I think the state does usually ask that question. I know there was no objection on that issue. I mean, that hasn't been challenged, so that's not been an argument on Palmer's point side.
Counsel, normally we don't let experts testify with regard to ultimate facts. So for example, you can't have the expert testify as to the ultimate legal conclusion or the ultimate conclusion that the jury has to reach, right? They can testify about their opinions to help the jury reach those findings or conclusions, but we don't let the expert kind of sit in the jury box and provide an opinion to the jurors. And so explain to me why that didn't happen here.
Well, first of all, KSA 60-456D does say testimony in the form of opinions or inferences. It's not objectionable because it embraces the ultimate issues. So it specifically
embraces, but not, yes, factor 4 is met, factor 3 is met, factor 2 is met.
I mean, the 10th Circuit case law that Palmer cites that interprets the corresponding federal case law says in these type of situations, experts can testify as long as they explain the criteria that are used and the reasons for reaching that conclusion, which definitely happened here. Both of the state's experts testified, I find he's a sexually violent predator because these are the 4 statutory criteria. And then with respect to each of those criteria, walk through why they believe each of those criteria was met.
And in fact, I think during some testimony of Dr. Crane, and perhaps it was after counsel objected, she even said, well, of course, the ultimate issue here is up to you, meaning the jury.
That's correct.
But here is my opinion. She noted that. Was there a jury instruction or something else to that effect?
I mean, the jury was definitely told that they need to find that all these elements are met, and it's up to them to determine whether the state proved those beyond a reasonable doubt. I would also point out within the Sexually Violent Predator Act itself, KSA 59-29-A05D actually says that the expert should offer an opinion. I mean, after the probable cause finding, the person's transported for a forensic evaluation. It says as to whether the person is a sexually violent predator. So it specifically orders a mental health professional to issue an opinion on whether that person is or is not a sexually violent predator. So even beyond the general case law and statutory provisions within the SVPA itself, that's something that's committed to an expert opinion. So on the confrontation clause issue, I just also would point out that the limiting instruction that was given, it was to explain to the jury how they were to use this testimony, that they weren't to rely on what the expert said as evidence in its own right, just as an explanation for why the expert reached their opinion. So that further protected Palmer's due process rights to the extent he had them. I believe that covers all I want to address. If you have any further questions, I'd be happy to answer them.
Questions from the panel? No. All right.
Okay, thank you.
Counsel, you've reserved 6 minutes for rebuttal.
So I know you have questions. Before all of that, I kind of jotted down a few points. So first and foremost, if this is an absence of due process, it's denial of a fundamental right. I know that's not briefed, but that is an issue in all of this and how the court considers all of it. Secondly, the collateral estoppel res judicata was brought up, the proving some new form of dangerous, a change in mental state that is dangerous, because had Mr. Palmer, for example, not gone to prison or not been charged with anything, there wouldn't be a basis to start a type of civil commitment, which is what we see in Sporn and Spiegler, is that there can be a change where somebody who otherwise before shouldn't have been civil commitment is now or has developed into a state where they should be, and there is elevated dangerousness. But I think the big issue here is that when the state began this commitment, they cast a really wide net and they kind of tried to Frankenstein together two different crimes to get the things they needed. They needed the imprisonment, the term in the Kansas Department of Corrections for the commitment to begin, because statutorily commitment always begins from a point of incarceration. And then they needed the sexual offense. So on the one hand, in the original arguments and pretrial hearings over this, when there was an argument about res judicata, that was brought up that the state very much leaned into, well, the predicate offense is the 1989 conviction. However, you get into the testimony of the experts, and they are both testifying that, well, these things that happened in 2012, they add to the dangerousness. And
aren't those two different questions? I mean, there's a predicate finding that must be met, that the defendant has committed a sexually motivated or a sexually violent offense. And then there is this person, or does this person continue to be a danger to the public? Those are two different findings, and that means they can involve different kinds of evidence.
They can involve different kinds of evidence, but that gets into the collateral estoppel issue right there. The state pointed out that the court didn't make a finding. Well, the court not making a finding doesn't mean that it's open. When the issue is resolved, when Mr. Palmer went to the Kansas Department of Corrections, the court had a choice to make a finding that it was a sexually motivated offense. That is something that would be moved for in the district court level at sentencing.
But was it necessary when there already wasn't a sexually violent offense on the books?
Well, I think so, because there'd have to be a change, and the state had to maintain that there was a change that would justify the civil commitment. And by accepting the plea or by presenting the plea offer, I think the state waived maintaining that there is a change. The state got a benefit out of it. They didn't have to go to trial. They got a guaranteed conviction.
Wait, doesn't the Easterberg case address this exact situation? So, the Easterberg court said it doesn't matter if the crime wasn't proven to be sexually violent in the underlying criminal case. You get a fresh crack at it in these commitment proceedings. So why wouldn't Easterberg resolve this situation?
And Your Honor, that's kind of blown out of my head in this moment. I'm happy to brief this afterwards if that's what the court needs, but I don't have a response to that right now. I'm sorry. So, but I do think, I mean, just going off of that with the idea that the state can get a plea agreement. And I mean, what Mr. Palmer was charged with, these were life sentence cases. And he had a prior conviction, so there were sentencing enhancements. If you had been convicted of aggravated indecent liberties, normally that's 25 to life. Off the top of my head, I think it bumps up to 40 to life. So the state waived a life sentence. If they could have taken this to trial and proven it, then the issue of civil commitment would have never come up in the first place unless Mr. Palmer were to be paroled, which would happen a long way down the line. So I think that comes into the context here too, that why didn't the state follow through on what it initially charged, asking for a life sentence, an off-grid felony, aggravated indecent liberties with a child under 14. It's a Jessica's Law case. And I know the Jessica's Law statutes have come since the Kansas Sexually Violent Predator Act was made law. And so to a certain extent, that has limited these civil commitments. But I think, again, there was something the state got and the state got a benefit, and they can't get that benefit and then get the benefit of coming back and saying, well, no, I think it's different now because we want this guy to be committed.
Other questions for the panel? All right.
Thank you very much.
Thank you very much. Thank you. We will take the matter under advisement. We appreciate counsel's argument, both in writing and today before the court. So we'll issue an opinion just as soon as we're able. With that, I'll call the second case on this morning's docket, understanding that we'll need to move some people around, but that case is case number 129205 from Jefferson County in the matter of the marriage of JEG appellant and CLBG appellee. Would the parties please come forward and state their appearances?
Please, the court, Devin Liam appears on behalf of the appellants.
Thank you.
Good morning, Jody Meyer, Law Office of Jody Meyer, appears on behalf of the appellee.
Thank you very much. And would the appellant like any time for rebuttal?
I'm 6 minutes, Judge.
6 minutes. All right. With that, you may proceed.
The appeal that I filed covers two separate issues, the financial issues in this divorce case and the parenting issues. I want to start off with the parenting issues because I think, frankly, those are the most compelling and frankly, were not addressed in the judgment that was provided by the trial court in this particular matter, which.
Let me stop you. Let me. Stop.
Yes.
So on the parenting issues, I understand there was a pretrial in this case and a pretrial order was generated. So it looks like your two parenting issues are the right of first refusal and then the failure to get the second opinion for the autism diagnosis.
Correct.
Were those issues identified in your pretrial order?
I don't recall off the top of my head. I know that we addressed them in the parenting plan that we did file with the court.
And when did you file the parenting plan with the court?
I believe it was a couple of weeks before trial. I know that my client had some changes as far as some of the issues that he wanted to address in the parenting plan. So I did redraft the parenting plan and filed that with the court and provided that to counsel for, at that time, the appellant at the trial court. So.
Okay, so you believe it was filed before trial or was it offered as an exhibit during the trial?
I believe I filed it before trial. If I'm wrong on that, I'm wrong on that, but that's my recollection of the way I proceeded on this matter.
Okay.
The reason why I believe the parenting issues are so compelling in this particular case are that there's a strong preference for finality when it comes to parenting orders. I know that to revisit a parenting order after it is set by the court, it takes a material change in circumstances going forward in the future, which is why it's vitally important that the parenting plan be complete and be as accurate as possible on the first bite at the apple, so to speak, because we don't. There is preference for finality, and there is preference that things don't be revisited unless there is a specific need to do so through a material change in circumstance, which is why the failure by the trial court to address either of these matters is somewhat disturbing, and frankly, from the appellant's point of view, an abuse of discretion.
Well, let me stop you again.
Oh, sure.
Okay, so let's focus on the right of first refusal.
Yes.
Which, a lot of us characterize that as the idea that if one parent can't exercise parenting time before alternative arrangements are made, the other parent gets an opportunity. Is that fair?
That's absolutely what we were seeking in this particular matter. And the reason for that is I think it's in the best interest of the child that the child be raised by one parent or the other. And before we bring third parties in to provide care for the child, I think it's an important right for the child to offer the right of first refusal to the other parent in the case that there is an extended absence that's needed by the one parent.
Okay.
That's the reason why I addressed that with the court.
So what was the evidence that was presented at trial to support that request? What was your client's testimony? What was presented?
It was my client's testimony. I believe that he testified that, again, he's a concerned father. He wanted to have as much time in his child's life as he could. And he believed that if there was something to where she needed to be somewhere else and could not watch the child, that he should be given the opportunity to watch the child before having a third party babysitter or other person be involved.
Okay,
Um,
and so then the court issues a parenting plan, right, at the conclusion of all this, and doesn't award your client this right of first refusal. Did you ever object that the court's factual findings weren't sufficient?
I mean, at the time, you obviously did not find out that the court did not address it until we got the judgment. And my recourse for addressing it, in my opinion, was through the appellate process. And that's why I did file that particular provision in the appeal motion, was so that this court could take a look at the facts, take a look at the record, and make a decision as to whether or not failure to address that issue in its final judgment represented an abuse of discretion. So it was my opinion that this particular court was my immediate remedy to address those particular issues.
Okay, and I want to make sure we give you time to cover everything. So on the second parenting issue, the failure to address getting a second opinion for the children's autism diagnoses, what evidence did you offer at trial that this second opinion was warranted?
I think there was a testimony. My recollection is that both parties, during either cross-examination of the appellee or direct examination of the appellant, talked about the fact that this was a multilingual home, that English and Spanish were both spoken, but Spanish was the primary language that was spoken in the home. And that's a key factor in deciding on whether or not this was a proper diagnosis, because I believe the testimony of the expert that testified on the issue of the autism diagnosis, everybody was clear that the test was given in English. And there was some complicated issues that were discussed in this particular investigation and diagnostic tool of the child, such that if the child did not understand the language, that it could affect the outcome.
But the respondent brought a witness, the children's doctor, Dr. Ashley Bloom, and that doctor testified about the diagnosis.
Right.
Did you offer any evidence, medical evidence, to controvert that?
No medical evidence to controvert it, but I think the record was clear that Ms. Bloom did the evaluation in English. And with this being a multicultural home, that's the reason why we wanted the second opinion, to make sure that the children understood the questions that they were being asked of them. That wasn't clear from any of the testimony and any of the record that was offered in this particular matter. There would have been no prejudice to the appellee to allow that to happen. I believe my client said that would be at his cost that we would do that. Autism is a vitally important issue to get right. It doesn't carry the scarlet letter that it did years and years and years ago. But autistic children see the world in a different manner. They process information in a different manner. And their educational focus needs to be done differently than those who are not autistic. So it is, in our opinion, it is better to do two evaluations and make sure that we get it right than to depend on the one evaluation where it's not clear that the children understood or given the opportunity to process the information in their primary language that was spoken at home, which is Spanish. It's in the child's best interest that we get it right on the front end, so that, I mean, if the children are autistic, that's not, again, a scarlet letter. That's not something that's going to sentence them to being behind in the educational system. Our educational system has come a long ways in addressing these through IEPs, through 504 plans, and make sure I get the number right. But there.
Did Mother state on the record that she didn't object to a second opinion?
I thought she did. I thought she didn't care if there was a second opinion, especially given the fact that my client was willing to pay for that. That's why it was concerning that the district court did not address it in their findings, because it's not clear from the record whether the judge reviewed it and made the decision that it was not appropriate, or that he just did not address it or forgot to address it in the record, and it needs to be revisited. That's why we're asking the court to remand this matter back to the trial court to make specific findings as to its opinion, whether or not a second opinion on autism is warranted. That's the remedy that we're seeking from this court on that particular issue. I think I've exhausted the the parenting issues, turning to the financial issues. Obviously, equitable division is addressed in the Kansas statutes 2711 plus case law. It does not have to be 50-50. There is a 10-factor test for the division split under 23-2802C. I believe that it was factor 8 was the analysis for the inequitable split based on dissipation of assets.
I'm going to stop you. I just want you to know that we're through your opening argument time now, but if this is something that you'd like to address now, we can just kind of take a little bit of time out of your rebuttal so that you can address it now.
Sure, that's fine. Probably I can do this
Right.
in a minute. I think the crux of my argument is that the court did not abuse its discretion in ignoring my client's testimony as to Exhibit L, which was the main document that was offered by the other side with respect to the reason for the inequitable division in this particular case.
When your client testified, did he discuss the fact he stopped, it looks like paying the mortgage, stopped depositing into the joint account, providing support, withdrew his paycheck from the joint account, stopped paying health insurance premiums, daycare, school fees, and then bought a vehicle? Did he testify about that?
I believe he did. I know that there was discussions that the accounts were switched from the marital account because of the conflict going on in the marriage with respect to the accounts, that he switched it to his own individual account, but that he did continue paying for some of the costs. That's my recollection of the testimony in the case. I guess to wrap it up, to save myself some time for rebuttal, my position is that the court did not properly consider the evidence and testimony in the case and did not follow the factor analysis correctly in deciding to do an inequitable division in this case. And I will defer the rest of my time for rebuttal. Thank you, judges.
Counsel, I think you have reserved 4 minutes for rebuttal.
Thank you.
You're welcome. Good morning.
Good morning, may it please the court. Appellant raises essentially 3 issues on appeal, and the standard of review for all 3 of those issues is an abuse of discretion by the trial court. It's the appellant's burden to designate a record sufficient to establish a claimed error, and without that record, his claim of alleged error fails. Assertions in an appellate brief are not sufficient to satisfy inadequacies in the record on appeal. So therefore, appellant has not met his burden in any respect to these issues. I'm going to go ahead and address the issues of the child-related issues, since that was the majority of appellant's argument. And there are 2 really separate issues. Regarding the autism evaluation, I would note that I think that was brought up in the pretrial statements, and certainly there was a lot of testimony at trial about that. And I would admit that that the appellee at trial said she didn't have an objection to that. However, there was extensive testimony that there was more to the autism evaluation than simply whether or not there was a language issue with the children. As noted in the transcript, the children were very young. The 2 children were very young at the time that they had the evaluation. Dr. Bloom, the pediatrician who testified at trial, was not the person who did the autism evaluation. I think it's specific to clear that up. The University of Kansas did that autism evaluation. Dr. Bloom testified at trial that she had noticed things in her assessments of the children that caused her concerns about autism. That led to recommendations at the University of Kansas to get those evaluations done. Then there were other folks involved. The appellee testified at trial that the children had various professionals who provided support. I think there were speech and occupational therapists. All of these people witnessed these things to support the idea that the autism was there. There is no basis other than the appellant's opinion that there was an issue during the assessment with the children and the language barrier. I'd also note that Dr. Bloom in her testimony at trial noted that she has a degree in Spanish, as well as her undergraduate degree. So I think that Dr. Bloom was well aware of potential issues that could arise. So I would also note that the trial court asked some pointed questions to the parties regarding the evaluation and noted that he had family members who had autism as well. So I think it is safe to consider the fact that the court, even if my client did not have an objection evaluation, looked at the substantial competent evidence and made a determination that a second autism evaluation was not necessary. And so in looking at all that evidence from the trial court on that issue, I do not believe that anyone could say that the trial court abused its discretion in not granting that. Now, did the trial court make a specific finding that it was not going to grant the autism evaluation? No, the court did not do that. However, the appellant could have asked the court in a motion pursuant to 60-252B to make additional findings, amend the findings, did not do that. And in addition, he did not object in any way to the, I guess, if you want to call it, inadequate findings of the trial court. And it's in the absence of that, that omission should not be considered on appeal. Regarding the issue about the right of first refusal, I would note that that was not an issue, according to the trial transcript, that there was testimony about. And there, in my review of the record on appeal, the appellant's proposed parenting plan was not filed with the district court. It appears that it was an exhibit at the trial, that both parties produced a parenting plan at trial, and appellee's was filed with the district court. And it appears from the testimony that there were multiple things in the appellant's parenting plan, because there were some references to specific things. It sounded like there were a lot of various items in there, and that the court, reviewing those parenting plans, decided based on the testimony of the parties that he was not going to adopt that particular provision of the appellant's parenting plan. And if you look at the evidence before the court, there was a great deal of testimony from the appellee regarding the history between the parties, domestic violence, other issues between them involving exchanges at police departments or calling the police. And so if you consider all those factors, and additionally, I might add the distance between where the parties reside, I think that you could say that there was substantial confidence as the trial court had to decide not to adopt that specific provision of the parenting plan. And like the issue with the autism evaluation request, the appellant did not request the court to make additional findings as to specifically why he didn't adopt a right of first refusal. And therefore, in some ways, I think that he waives that argument. I'll move on then to the issue of the, I guess, property division. Like some of the other issues, there's not a sufficient record on appeal regarding what they believed the judges, the trial court's position to be in terms of how he abused his discretion in that division. There was nothing provided by the appellant prior to the trial that specifically suggested what his proposed division was. At the trial, he offered a great deal of testimony regarding the ins and outs of this joint bank account, or what's characterized as withdrawals from an account. And he essentially stated that he was worried that the appellee was spending too much money, and so he was giving it to his father, using it for various things. But at no point in the trial testimony did he really say what he was specifically wanting in regard to these various issues, other than his repeated assertion that he wanted an equitable division. And I think it's very important to note that at the conclusion of the trial court judge, after hearing all this, requested both parties to provide to the court, filed with the court, their proposed division or accounting, if you will, of the numbers and who's to get what. And there's nothing in the record on appeal with the district court or otherwise that indicates that the appellant ever filed such a document. There is evidence to show that the appellee's attorney did in fact file her proposed, I would call it findings of fact and conclusions of law in the form of a proposed decree. that included all of those financial matters.
Let's pause for a second. So it looks like the appellee received 15,951 and some change. Does that represent half of the funds that, she alleged the petitioner withdrew from the marital account? How did the court get to that?
Well, to be frank, I am not certain how the court arrived at that conclusion. The exhibit that's been referenced was not included in the record on appeal. And so I don't know. I mean, there's a general statement in that decree that was filed with those findings that that's what it was for, representing 1/2 of the expenditures. So
And this exhibit L was a ledger of the transactions. Is that correct?
it was a ledger of the transactions that I believe was prepared by appellee's trial counsel. That was an agreed exhibit for the court. And I don't believe that the appellant provided any documentation of himself other than his testimony to essentially explain or refute these various transactions that were in this exhibit. So essentially, in looking at the brief that was provided by appellant, I mean, it's not entirely clear what it is he's even asking today, other than the references to the withdrawals from the account. I assume that that is the issue, the only issue, as opposed to all the various other items in which the court ordered be paid to my client before dispensing equal shares from the sale of the residence. For example, repayment for the down payment on the car loan payments, expenses for the children, all those are things that the court ordered that she be reimbursed for. I assume, because that hasn't been brought up today, that those are non-issues and that we're strictly just focused on the issue relating to the withdrawals, if you will, of the account. But again, did the court have substantial evidence to make the decisions that it did? And if you look at all the testimony by the appellee at trial, there was extensive conversations regarding the financial situation that she was put in. I will say prior to the filing, but during the filing, when the appellant stopped putting his paycheck into the joint account, was making withdrawals from the joint account after he stopped doing that, which means that she was solely paying those things, wasn't paying the other things. The record also indicates she was having to get financial assistance from her tribe, other people that left her to the position where she couldn't even pay the mortgage and was having to have deferrals on that. And as noted by appellant's or appellee's trial counsel in closing, appellant's actions were in violation of the temporary restraining order in the case that ordered that the parties were to continue the status quo essentially and not change the manner in which finances were happening, like say, for example, the deposit of his check into his own account. Appellant's testimony at trial was, yes, he did that, but he was specifically asked and specifically testified that his financial situation was quite good, that he wasn't living paycheck to paycheck, and there was no, so essentially there was no financial burden on his part. So I think for the trial court and hearing all of that evidence of both parties and considering the exhibit, thought that the appropriate thing was to reimburse her for 1/2 of those withdrawals. Wasn't the whole entire amount, it was 1/2 of those withdrawals. So in light of everything that this court has before it, I don't think there's any way that anyone can say that the trial court abused its discretion in making the decisions that it did. And I'll stand for any questions that you have.
Thank you. Further questions for the panel? All right, thank you. Counsel, you've reserved 4 minutes for rebuttal.
Starting with the financial side of it, I think the court, it was even brought up in the last argument that it's not clear from the record how the court arrived at the $15,000 division figure. I guess that's where we're coming from. I think the lion's share of the evidence was dependent upon that exhibit L that was presented at trial.
Counsel, did your client or did you provide anything to the district court to make a decision about the division of property following the trial?
I do not recall. I don't recall the court's. I don't recall the court specifically asking for that. So the answer would be no, I don't believe we did. We relied on the fact that we presented Exhibit L, the other side presented Exhibit L, and we took great pains to go through Exhibit L at trial to explain that this was not a dissipation of funds. This was not a violation of the court order that was in place in the pretrial. This was how he made sure that he was able to have finances for himself, but that the other side was still provided for. I don't think the evidence was sufficient, and the court did not make it clear in its judgment how it arrived at the $15,000 figure, which is why we believe that that did represent an abuse of discretion. Now,
What financial records did you include in the record on appeal for our review?
I gave great reference to the Exhibit L, which I believe was part of the record. I do want to turn my attention to since I've got 2 minutes left, I want to make sure I address the parenting issues. I hope I addressed the court's question on that, but the autism issue is, I mean, both autism and right of first refusal are both important, but again, I think it's extremely important that we get the autism question right on the front end, because as the appellee noted, and the testimony in this case was the children were very young at the time they were given the evaluation. Given that
In the
Spanish was
absence
the
of a ruling by the district court, has your client sought a second opinion? Is there anything to prevent your client from seeking a second opinion?
I think he's wanting to follow the parenting plan as closely as possible. And I think he's concerned, and I think
Counsel, is there anything to prevent your client right now from seeking a second opinion?
I guess just the objection which hasn't been made, but I know that every time that he has raised issues with the appellee on all issues related to the parenting plan, she's come back and said, we have to follow the parenting plan. So the fact that
in the parenting plan that prevents your client right now from getting a second opinion?
I don't believe there's any language in there specifically preventing him from doing it.
So what relief are you seeking?
We're seeking a remand to the district court to make specific findings authorizing how it's going to be done, if it's going to be allowed, and if so, how the payment's going to be made for that. I mean, if there's no language in there, I suppose my client could go get that done, but he doesn't want to open a can of worms that will lead them back to the district court. I guess the big thing is this was a very contentious divorce, and it's been contentious after the divorce with respect to the parenting plan. And my client's trying to be extremely careful to make sure that he does not do anything that's going to cause him to have to go back to court to state that he is violating the parenting plan that was issued by the court, which is why we just want some definitive language in the parenting plan that addresses how a second opinion on the autism would go, because his time with the children is far less than his wife, and he wants to make his ex-wife, and he wants to make sure he does things following the parenting plan. Thank you. It looks like I'm out of time.
All right, thank you very much.
Thank you.
The court will take the matter under advisement. I'm going to thank counsel for their arguments today and in the briefs, and we'll issue an opinion as soon as we're able.
Thank you, Your Honors.
All right, with that, we'll turn to the third case on this morning's docket. That case is case number 127790 from Johnson County, State of Kansas appellee versus Daniel Michael Marshall, appellant. Would the parties please state their appearances?
Please court appellant Daniel Marshall appears by counsel Kate Zigtma. I'd like to reserve 5 minutes for rebuttal.
5 minutes are granted.
May it please the court, your honors, my name is Maria Davies, and I represent plaintiff appellate State of Kansas. Mr. Minahan wrote the brief, but he's unavailable.
Ms. Davies, have you entered your appearance in this matter?
Yes, your honor, it was in June of 2026.
Excellent. Thank you very much. With that, you may proceed.
May it please the court, whenever y'all are ready. This case seems kind of new and interesting and exciting, but the reality is there's no new law here. There's no new exciting law. It is just Edgar. It is just Strickland. It is just Lafleur and Fry. The twist comes because we have a different procedural point in time that we're looking at this analysis. And because frankly, no one's ever talked about KDOC classification in this kind of context before. So the biggest part is where the district court went wrong is one, this should have just been in Strickland. I can try to bootstrap my way into knowing involuntary, but it's a Strickland issue. This is a competent counsel issue. And the reality is there was this not uncommon, but not common in the case law situation of we had alternative plea bargains offered. And so this is the unique facts. The critical point is advising the client when choosing between the alternative plea bargains. This is different from all the other motion to withdraw pleas where they ended up going to trial and got the full boat or whatever. But when you have to choose between two plea bargains, then that's where the reasonable investigation, which is a key Strickland part of any kind of Strickland analysis.
Counsel, it looked to me in reading the record as though Mr. Marshall was singularly focused on probation versus prison. Is that accurate?
Judge, I think that the court could read the testimony that way, but they did also talk about they wanted to look at work release. The state wasn't going to go there. And I think that comes back to sort of a core function of being defense counsel. Our clients want a dismissal. They want an acquittal. They want, the stars and the moon and the state to pay for them and all their trouble for having to retain an attorney. I quoted the Rolling Stones, but that's the moral of this case. You can't always get what you want. And so it's one of those things where a defense counsel has to work with their client to tell them, I know that's what you want. This is what you need. And the problem with Mr. Marshall's case is he didn't know he could get what he ultimately needed, which was he wanted to keep his job. He wanted a minimal interference with his life. And the reality established by the remand hearing is that if he had taken this prison plea bargain, the district court find more likely than not, he'd be minimum security, and more likely than not, he'd be going to work release.
One of the things that I've struggled with here, first of all, how can we require defense counsel to know all of these ins and outs when I'm reading them and thinking this is very difficult, but also how it's still just a likelihood.
Well, what I would say is I understand the court's point, but that's really the position defense bar was in when Padilla came down. None of us knew anything about immigration. And all of a sudden we had to start learning about immigration and telling our clients about immigration. And this is slightly different because usually defense counsel is like, hey, go talk to Sharma Crawford or an immigration attorney. Like go talk to somebody who knows what they're doing and then come back and tell me what they said, or I'll call them and they'll tell me what we got to do here. There's no one like that for KDOC. The only person who could be like that for KDOC is the defense bar. I mean, who's supposed to know this stuff besides the criminal defense attorneys and the prosecutors and, DOC? So that's the difference.
I have a question kind of going down the Padilla road. So the way I was looking at this, if you're looking at ineffective assistance, we have a number of decisions like McCauley, Moody, Wilkinson that say, counsel has a duty to advise of direct consequences, but not collateral. And the way I read Padilla is like it's saying deportation is kind of its own category. Like you can't call it collateral, you can't call it direct. So why would the consequence here, with the classifications of KDOC, why would that fit into a direct consequence?
I think the court is kind of making the same mistake the district court found. We're not looking at the point once we enter the plea and before you sign that dotted line and say guilty, you are fully aware of what your consequences are. We're a step before that. We're picking between the two. So we're back in a reasonable investigation level, sort of like, why didn't you call an expert? Why didn't you present this witness? It's a step back from that, which distinguishes it from those situations. And most of the time, this isn't going to come up. If the option is plead as charged or plead to this amended charge and go to your guideline sentence, okay. I mean, it's going to change your sentence duration. It'll change your charge. It'll change you from, presumptive probation to presumptive prison, whatever the case may be. We don't have to go to that second level. This second level had high risk, high reward for the one, and the client, needed to know this was high risk, high reward, but there's no appeal and there's nothing we can do if we don't get this. But there was a second option that had this other layer to it that really made it the more appropriate plea for a low risk, a low risk, medium reward, I guess. But I mean, in my experience, no district court's going to say, oh, level 9, go do your time is the agreement. Okay. I mean, they're signing that line every time. So that's the difference here, is it's not a question of did he know when he was entering the plea about the consequences of that plea? It's that he didn't have the information to choose that plea.
What kind of information? I mean, I know what information we're talking about here, but how do we assess that? If we open that door, how do we assess what information needs to be provided and what doesn't? I mean, that feels like that's a very difficult way to go down.
I understand what the court's saying, but that's why the investigation standard is what it is. It's reasonable limits on investigation based on reasonable investigation. It's no different than anytime we take that standard to a trial, which is always going to have its own facts and circumstances and players, because even though you could say the general rule is you have to have an expert if the state has an expert at trial, maybe not. I mean, it's all going to depend on the facts and circumstances. And that's what it is here. It's not a new law. It's that you have to have all the facts and circumstances to make your client or allow your client to make this decision. And that kind of comes down to the other thing is all of this information was publicly available. And the classification is almost a static instrument. It's like, what's your criminal history? Did you ever have an escape? All things in the PSI, all things you can get about disciplinary reports calling over to the jail, all things you get from talking to your client. And so it's not like we're asking you to predict the outcome of a psych eval. We're not asking you to predict what a neuropathologist is going to say. What you would have to advise the client is pretty much exactly what I said in my brief. Look, DOC, maybe they give you an exception, maybe not. They don't usually do that based on what I see. This is what I think is going to happen, but I can't guarantee it. And that kind of leads me to the Bricker issue. If my client had been advised of the work release minimum situation and gone that route, and then whatever happened at DOC that it didn't happen, I think that's when he's like Bricker, because we can't control DOC policy. But I do think it's a reasonable investigation and a reasonable thing to require that attorneys advise their clients about what they're looking at in the future to the best of their ability. They can't say it's for certain. If they say it for certain, then we're kind of back in normal plea territory or withdraw plea territory. But that's the point of attorneys. One of the things that stood out to me in the state's brief is they said, well, the district court wouldn't have to go through this. And I agree. But why should defense attorney? Well, that's our job. That is our entire job, is to make sure that you know all the things, all the information that you should reasonably have to make your decision. And if we're just going to go with, all that you have to tell you is what the court has to tell you, why are attorneys there? I mean, the court's going to tell you what your max is. The court's going to tell you what your guidelines are. The court's going to tell you your trial rights. It's that critical point where when we're making those behind the scene decisions, we have to give them enough information to make their decision. And that's where I think we go astray here.
Is the thing that puts us in Strickland versus Edgar, I mean, whether there is a meaningful difference between those two is perhaps debatable, but there's a thing that puts us in Strickland, the fact that this is an alternative plea deal.
I think it is, because well, let me back up. Edgar basically says, once it's post-sentencing, we're applying Strickland. I don't disagree with that. I use the phrase deficient performance because that's something we use on the ineffective assistance of counsel side all the time. That's not a different standard. That's just the reasonable performance standard. And so I've lost my train of thought, but
let's talk about, what would have been different. So if he would have been given this information, what would have been different? Would he have given up the opportunity to argue for probation?
Yes, he would have given up the opportunity to argue for probation. And he testified that he would have rather done this. The unique thing about this case is this client figured this out in RDU and went, what in the world? If I had known this, I would have made a different decision. This isn't some attorney came up with an idea a minute, like, hey man, if you knew this, would you have done something different? He was shocked when he learned this because this is what he would have chosen. And he testified to that fact. The district court didn't, the district court focused on probation and he wanted probation, but we're back to the stones. I mean, you can't always get what you want. And I don't think the district court ever really made any sort of factual findings about, well, if he had known this, he might have gone for work release. The district court was kind of stuck at the, when you entered the plea to go for probation, you knew you wanted to go for probation. And you've got to back it up a step. Because all of these kind of ineffective assistance cases are, I call them choose your own adventure books from the 80s, right? Like you read to page 15, it says, if you want to go left in the cave, you go to page 42. If you want to go right in the cave, go to page 53. And that's what this is. You have to back that up in time and make those decisions there because it changes the route and it changes those decisions along the way. If the court doesn't have any other questions, I'll reserve my comments about Lafleur and the remedy for rebuttal, except to say that I'm pretty sure Lafleur, clear as day, says that if we have to purge the constitutional taint. And in this case, the only option to do that is to vacate the conviction sentencing and then go forward with the other plea. I'm asking my client to go to prison just for a different charge for a different amount of time.
All right, thank you.
Thank you.
Counsel, good morning.
Morning. May it please the court, Plaintiff Appellee, State of Kansas, Maria Davies. So Marshall made a calculated strategic decision to choose the severity level 7 plea to gamble for probation, and he deliberately rejected the level 9 offer that guaranteed prison time. And having lost that gamble, he now seeks to withdraw his plea by conflating discretionary prison administrative policies into constitutional error. So the first prong going to discuss is that counsel in this case had no legal duty to advise on collateral discretionary prison policies. Due process only requires advice on direct consequences, those that are definite, immediate, and largely automatic. And KDOC classification, I'm going to go through KDOC classification and work release policies, but those are both highly subjective, multi-tiered, and non-automatic. There are subjective overrides, there's physical constraints, and there's fluid rules. And those were outlined very much so in detail in volume 7 and volume 10. Going through a couple of those, even with an initial minimum security classification, an inmate may still be placed in a high, medium, or high levels of custody, and that's depending on bed space. Defense counsel would have had no way to predict what the bed space would be at KDOC.
Counsel, as I interpret opposing counsel's argument, it's not that the attorney had to provide the exact what exactly happened, but had to at least provide some information so the defendant could meaningfully distinguish between what these two options look like beyond high risk probation versus this other option. Are you interpreting that differently?
So Your Honor, I think something important to consider is that Marshall clearly testified at the Van Cleve hearing that he had wanted probation. That's also what Lewis testified. So the goal really in this case was probation. I think it's also important to note.
Was there any testimony, though? What I really wanted was probation, but this would have changed my calculus.
So in hindsight, Your Honor, in volume 7, Marshall does testify that if he would have known about this, that he would have likely accepted. So that really goes to, Your Honor, I think that Marshall cannot show Strickland prejudice, even though Lewis did not have the duty to go through this with him because it was not a direct consequence. It's important to note that his strategy was to avoid prison entirely. And he cannot show a rational probability that he would have objectively accepted guaranteed prison time merely for minimum classification or work release. Trial counsel confirmed that Marshall wanted probation, and Marshall's own testimony at the Van Cleve hearing was really illustrative of that. He said he was scared of prison. He viewed it as unsafe. He even had obtrusive thoughts about it.
Since we're talking about the Van Cleve hearing. That's part of the difficulty with this case. It went back to a Van Cleve hearing, and it essentially was treated as a motion to withdraw a plea and using the Edgar standards. Do we have a finding by the district court on prejudice?
So, Your Honor, I think that in this case, it was important to note, and the appellant noted in the brief that they said that he would likely have got minimum classification, but the court also said that it was not a guarantee that he wouldn't have, that his classification wouldn't have been raised or moved up. And also it was not a guarantee that he would have got work release. So I think that the court addressed it in that way, that he wasn't prejudiced because there was no guarantees. And so that goes back really to the state's argument that these two different factors, KDOC classification and work release, there's subjective overrides, there's physical constraints, there's fluid rules. It's important to note that an intake investigator conducts a detailed evaluation and they analyze the resident's file, disciplinary reports, residents in the behavioral health unit, and the investigator's impression of the resident. And so that shows that there's so many unknown factors. And at the sentence,
There are many unknown factors, but there's kind of a presumptive route, is there not?
Your Honor, can you expand a little bit more?
That there, depending on the classification, that there's kind of, it's presumptively that someone is going to, with the plea and the conviction that Marshall has right now, it's presumptive that he will be in medium to high security. Whereas if he had gone with the other plea, it's presumptive that he would have been in a minimum security provision. And each of those have differences that are notable.
So a couple of those 6 factors, yes, Your Honor, are more static, such as the inmate's age when they enter into custody, prior criminal convictions. But something that was important to note about that initial classification was at the Van Cleve hearing, the KDOC witness did testify that Marshall scored 0 on the hypothetical institutional adjustment. But the KDOC witness also said that she did not have any information about how he behaved when he was in the county jail. So there were some things that were static. However, that's not static. We can't predict how his behavior would be in jail after sentencing or how he would behave at RDU. And then also, Your Honor, they testified that there's no guarantee that he would have, even if he scored the minimum classification due to space at KDOC, there's no guarantee he could have been classified upward.
And, nothing in these trials is guaranteed. And so I'm just trying to figure out, if someone is, we require defense counsel to talk to their clients about potential sentencing outcomes when they're looking at a plea. But as we know, that sentencing outcome, even within the grid box, there is variation. And then, if they are asking for a departure sentence, then the counsel still has to talk to them about, here's the likelihood of a departure. Here's, the judge doesn't have to provide a departure. Is it unreasonable to ask for defense counsel to tell them a little bit more when you're faced with this kind of interesting and unique situation of alternative pleas?
So I think, Your Honor, going back to, again, counsel can't predict what some of these humans are going to subjectively believe or rule at KDOC, but going into your question more, he had testified that he wanted to avoid prison in this case. He wanted probation. So I think that this case is very different. If maybe defense counsel in a different case affirmatively misled him and knew that he wanted work release and tried to go through all these different classifications and said, yes, you're going to score minimum, you're going to get work release. So I think there's different situations where maybe someone would have the duty to do that investigation, or at least not affirmatively mislead. But that's very different than this case, because Mr. Lewis did not affirmatively mislead his client in this case, knew what his client's goal was, probation, and there's no way really that he could have predicted what these people at KDOC would determine.
If there are situations where it might be important to provide that information, I understand that it's your position that this is not one of those situations. How do we determine what those situations are?
So I think that would be more analogous to a case where they're talking about someone's criminal history and maybe counsel is completely wrong on the criminal history, or where they tell their client, yes, if you plead to this, the judge is going to have this outcome. But again, that's not what happened in this case because he didn't affirmatively mislead. So maybe if Mr. Marshall had told him that he wanted work release and Mr. Lewis said, okay, when you go to KDOC, these are the different factors. They're going to classify you as minimum. They're going to give you work release. I think that would be a very different case.
But what do we do with Padilla?
So Padilla, Your Honor, I think as the court was discussing earlier, state's position is that Padilla created a narrow exception for automatic deportation. And the state's argument is that does not extend to internal administrative prison classifications. This was not something obvious that Mr. Lewis should have known. In Padilla, I believe that the court ruled the deportation was something very obvious that trial counsel should have known and been able to advise the client on. So deportation is very different from work release and classification in this case.
So Padilla is just an immigration case having to do with deportation, and that's it.
Yes, Your Honor, because deportation is very unique, especially in this day and age. So it's different than the usual direct and the collateral distinctions. Something that also is important is at the sentencing hearing, trial counsel has stated that Marshall was diagnosed with bipolar disorder, generalized anxiety disorder, borderline personality disorder, and ADHD. And when asked at the Van Cleve hearing, the KDOC witness said a factor like bipolar disorder or mental issues that someone is dealing with would typically increase the classification, or it could remain the same. That's another unique factor in this case, Your Honor, where Mr. Lewis wouldn't have been able to predict how that would have played out. And then also it's important to note that about a quarter of the prison population gets an exception and is reclassified, and that shows that the system is highly discretionary. Moreover, the trial court can't order that someone go to KDOC and be classified a certain level or be given work release. And so I've been kind of focusing on the classification, but work release also is not definite, it's not immediate, it's not largely automatic. The eligibility requires that the inmate be physically capable of seeking and maintaining employment and maintaining behavioral health. Again, that goes to the facts of this case. Mr. Lewis would not have been able to predict if there was even going to be a work release program available to Mr. Marshall, and if Mr. Marshall, because of his needs, would have been able to successfully complete that, take medication. Also important, Your Honor, going to the physical limitations, same kind of as the classification at KDOC, a lot of this has to do with space. The KDOC work release has a capacity of 450 men. So Mr. Lewis would not have been able to guarantee that his client would be able to get work release.
And it was my understanding that those were across all of the work release programs in Kansas. Is that accurate?
I believe so, Your Honor. That's in volume 10, but I believe so, at least from what the KDOC witness testified to. It's not guaranteed. There's a specific number of bed spaces. And Lewis correctly stated that he'd be highly hesitant to advise a defendant about work release because, to use his own words, there's not a lot of wiggle room. And he had no duty to predict that KDOC, how it would exercise its control. Then I want to go back to prejudice. I know I spoke about it a little bit at the beginning, but again, his strategy was to avoid prison entirely. He cannot show a rational probability that he would have objectively accepted guaranteed prison time because trial counsel confirmed he wanted probation. He was scared of prison, wanted to resolve the case with as little intrusion into his life as possible. And the plea was also knowing and voluntary, want to touch that prong. There was no manifest injustice. Mr. Lewis explained how he explains to his clients open to argue and factors that helped and hurt Marshall in this case. At the plea hearing, the court also informed Marshall of his sentencing range. It included a maximum of 34 months with presumed imprisonment. The court, even on the record in volume 3, he reinforced that if his sentence resulted in presumed prison, the state would argue that he should serve the mid-box term in prison. And the court also explicitly asked Mr. Marshall if he had any questions about the plea agreement. So he entered into this plea knowing and voluntary. He knew what the factors were, knew what he was entering into. There was no way that he could have guessed. There was no way his attorney could have guessed or the court could have guessed what would happen at KDOC. And so Marshall made a strategic gamble to avoid prison. One of the options allowed him to argue for probation. He lost that gamble. He now has buyer's remorse. Absent any other questions, I would ask this court to affirm.
Questions? All right, thank you, counsel.
Thank
So I think one of the big points I'd like to start is I think there is, I didn't argue it in the first half, but it's in our brief. I think there is some mutual mistake here. The evidence was pretty clear that the state didn't want to give him work release. I don't think they knew they were kind of giving him work release with that level 9 go to prison plea offer. And the undisputed evidence is Lewis didn't know that he would probably go to work release. And that's that critical factor. If your chances are, when you're only told, hey, we can ask for probation, it's like, yeah, that sounds great. Or you can agree to go to prison and you don't know what prison is really going to be like, or what the programs are going to be, or that you're going, you're probably going to work release. That's a huge factual issue that most clients, that matters to them most. What does my life look like after this? I think there is, the state kind of tries to reweigh the evidence by re-arguing all this classification information. We had KDOC testify. KDOC said, this is what he would end up being. While there were some things we didn't know because he hadn't fully been classified, if my client had disciplinary violations over in the jail, I would be shocked that the state didn't march the jail on over to tell us all about all his DRs, because that would have spiked this argument completely. So they almost want us to prove a negative here. If they had information he had DRs that would have affected classification, I anticipate that would have been presented at our hearing because it would have spiked my argument. There is, it is KDOC policy, but Padilla is, immigration is all about policy these days, and we still have to advise them and we still have to look into these things. So I think that just because it's a KDOC policy versus a specific statute and unable to be ordered by the court, that doesn't really take us outside of Padilla. Turn on the news, that we have all these policy issues. I think part of the other issue is that the knowing and voluntary, where we talk about due process considerations, that's a separate factor. We have to stay in ineffective assistance of counsel.
That's an issue. That's, I think, something that's bothering me a little bit. So, I know this was filed as a motion withdrawal plea. Normally that would trigger Edgar, but when you get to the sum and substance, it's an ineffective assistance of counsel claim. So how did the district court analyze that ineffective assistance of counsel claim under Strickland in its Strickland? Or did it?
They really didn't. And I don't know if this was some sort of hesitancy. Trial counsel is well respected here. I don't think that anybody wanted to label him ineffective. And so things got crammed into a different factor to try to skip over that part. But this is what this is. It's an ineffective assistance. It's a competent counsel claim. And even though the trial attorney here is very, very good, everybody makes mistakes. That's why we have motions to withdraw plea and ineffective assistance of counsel. So I think the district court erred by not doing that analysis. And that's part of why we don't have any real findings about prejudice under Lafler. Lafler at its heart was an error of law caused a rejection of a favorable plea. This is an error of law and investigation that caused the rejection of a favorable plea. But instead of going to trial, we picked the other plea.
Can you talk to us about the remedy?
So the remedy is pretty crystal clear in my mind for Lafler. Lafler says you have to purge the constitutional taint. And where that can be fixed by resentencing, you can just resentence. Where it cannot be fixed by resentencing, either because we amended the charges or some other criteria, something in the case makes it you can't fully restore the client to before the violation, the court can reorder to issue the plea. There's one, I wrote it down. I did not cite it in my brief, but there is an unpublished Court of Appeals opinion which kind of rejects this theory that the district court doesn't have the ability to order the state to reoffer a plea. And I can submit a 609 letter for that following argument. But the Supreme Court says you can. The Supreme Court is pretty clear in Lafler. This is what you should do to purge the constitutional taint. So I think that is the remedy here. We need to go back. We need to withdraw this plea. And my client's just going to plead to a level 9 criminal threat and go do his time. However, that time seems to shake out. And if he balks at that, then the court can always say, well, we did this so you could do this. You changed your mind at the last minute and vacate that.
And so explain to me, so like typically, you know, if you grant motion to withdraw a plea, you just go back to the drawing board. So the plea is gone, great. You know, some people end up going to trial but so why in this case must the remedy be he gets to accept the other plea?
Because that's the only way to purge the taint. And I think that if, for whatever reason, if we got to the point where it's like, all right, enter your plea to a level 9, and my client says no, then the district court goes, you know what? I'm vacating that order because we did this whole thing on the premise that you were taking this plea and that was the violation. And if you back out at the last minute, we now, you know, what are we doing? I think the court can say, well, I'm going to revisit my findings on this because you just backed out. I'm finding there's no prejudice and you wouldn't have taken it. And I think that's the appropriate remedy to navigate this. If my client doesn't take this plea, I'm going to be very upset, but it's his decision. And I think that's pretty much the only other thing I would say that I kind of noticed is having bipolar or some sort of mental illness. DOC manages mental illness all day, all day. I don't think the bipolar alone, if it's well managed and medicated, which there was no evidence this was not well managed, it would trigger an exception. But again, I'm kind of lured back to re-arguing the facts. The district court already found based on DOC's own testimony that this is where we would likely have ended up. If the court has no other questions, I believe that's all I have.
All right. We'll take the matter under advisement. Thank you very much. I will request that you submit a 609 with that Court of Appeals opinion, and you'll have the opportunity to respond as the state per the rule.
Thank you, Judge.
The court will take the matter under advisement and issue an opinion as soon as we're able. Thank you to both of you and thank you for pinch hitting today. It's great to have you here. At this point, the court stands adjourned.
All right.